Hi, I'm Valynda Jerome-Williams, staff attorney with Legal Services of Alabama. Today we will talk about heir property, the ripple effects. To contact Legal Services of Alabama, you may reach our mobile office at 104 St. Francis Street, Suite 700, or by telephone at 251-433-6560. We have a dedicated central office intake line that numbers 866-456-4995. You may also apply online at www.legalservicesalabama.org. Legal Services Alabama has 8 offices in a centralized call center working together to fulfill our mission statement, which is to serve low-income people by providing civil legal aid and by promoting collaborations to find solutions to problems of poverty. Our offices serve all 67 counties within the state of Alabama. Our physical offices are located in Mobile, Montgomery, Selma, Tuscaloosa, Anniston, Gadsden, Birmingham, Dothan, and Huntsville. We handle only civil cases. That means we do not handle criminal cases. Each of our offices are equipped with lawyers who are licensed in the state of Alabama, to provide legal aid, and also with staff who are trained to know how to serve people who need to navigate legal issues. How do we help people? We provide representation on critical legal matters in judicial and administrative forums. We provide timely counsel and legal advice. We use community education to teach people about their rights and responsibilities. We help provide effective mediation services to keep disputes out of court. And through our development and distribution of legal self-help material and forms, we help people to learn about their rights and their responsibilities. As you can see from the handout on the screen, we service various areas, including family law, domestic violence, public benefits, housing, consumer benefits, as well as heir property needs and estate planning. These services include land redemption, the drafting of wills, powers of attorney. So let's talk about heir property. Heir property is land that is held in common. It's usually passed down informally through the family. This is when the original landowner has died without having made a last will and testament, and the property passes from generation to generation. There is no clear title to property. This means several heirs may have a fractional interest in the property. So who is an heir? An heir is a person who stands to inherit or receive property from another person after that person dies. There can be disadvantages to owning heir property, which could also be referred to as family land. The vulnerabilities of having heir properties include a vulnerability to partition sales, vulnerability to tax sales. Heirs may have a problem securing a mortgage on the land. They may not be eligible for federal funding for housing or for other repairs. They may not be eligible for other programs that do require clear title to land, such as weatherization programs. The reason being is your federal government, your local government, they want to know who actually owns the land. They're not interested in providing services, whether it be a loan or a grant. They're not interested in providing that sort of resource to a whole group of people without any kind of security that they could hold someone accountable. There's also difficulty in getting property annexed into a city. And with heir property, there's difficulty selling timber off of the land because most timber companies, again, want to know who is the clear owner of the land. So let's talk about land laws in African American communities. Typically in African American communities, land passed through oral tradition. And this was so because many people were without access to the court system, without access to a lawyer. And from a cultural standpoint, this was the way of doing things, to give the property to the oldest male or to the oldest child. In 1865, this is where we saw in this country where persons who were enslaved, they became freed and they were first granted land ownership. At the turn of the 20th century is where we saw prior enslaved persons and their heirs come to own over 15 million acres of land. Most of this was farmland. By the 1910s, we saw a lot of rural Blacks begin to migrate to other cities. As time went on, we saw a decrease in the amount of land that African Americans owned. By the 1920s, African Americans owned farmland that represented 14% of farms in America. After the 1920s, we saw the implementation of Black codes, and then decades later, Jim Crow laws. All of this led to what we call the Great Migration. This is where we saw Southerners move from the Northeast to the Midwest and the West. Also, as time went on, we saw a lot of discrimination with regard to land purchasing and with regard to home rentals, land rentals. And so in 1968, we saw the implementation of the Fair Housing Act. In 1975, we saw African American owned farmland dwindle, and this continued to happen as decades came. In the early 2000s, we saw an increase in African American home ownership, but in 2008, there was a big financial crisis, and a lot of people lost their homes. A lot of people lost their land. And to bring us to where we are today, a lot of people in the African community are in what we call the rebuilding phase. They are in the process of obtaining land, in the process of obtaining home ownership. And people are putting more emphasis on estate planning and the need to clear up heir property, to clear up that title, to trace the land back to the original owner. In Mobile, Alabama, you can see there's a disparity in the home ownership rate between Caucasian and African American people. This is a source that I pulled back in, I believe, 2016. And for more information, you can take a look at that. These numbers reflect the disparity in land ownership throughout the country when it comes to African Americans. And a lot of this history that I just covered has a role in those final numbers. And so now we have people who are trying to reclaim their land. Our guest speakers today are Robert Zabawa, professor at Tuskegee University, and Dr. Kara Woods, also of Tuskegee University. She's a recent graduate. Dr. Zabawa was featured in the AL.com article back in November of 2019 called Alabama Descendants Look to Reclaim Land Clouded by Legacy of Jim Crow. For a link to that article, you can click on the link below. Today, our guest speakers will talk to us about the ripple effects of heir property, the importance of creating an estate plan, and what we can do to prevent this from happening. So without further ado, I want to present to you Dr. Robert Zabawa and Dr. Kara Woods. Thank you both for joining us today.
Good morning, everyone, or good afternoon, depending on when you are watching this video. I am Robert Zabawa, and I'm joined by my colleague, Dr. Kara Woods, and we're going to be doing a presentation on heir property. And before we get started, first thing we want everyone to know is that we are not lawyers, but we are people who've been working on this area for many years, and we have information to give, and hopefully there'll be information that then you can take to other people on down the line as you need it. One thing we will say is that if you have heir property and you are trying to resolve some of these issues, you will need a lawyer. So anyway, put that in the back of your mind, and we'll go through this. And if there are any questions afterwards, we will leave our contact information, and we'll be happy to answer those questions as you send them to us. So the first thing is we're looking at what's the situation and sort of what brought us to look at this topic. And one of those is this idea of land ownership, okay? Heir property deals with property, but the major point of the property we're looking at is, of course, land. And land ownership has been a privilege denied many communities of color. It's been stolen, it's been lost, and what we're talking about here is in the South. Now, other communities, such as poor whites in Appalachia, the Latinos down in the colonias, the Hispanic land grants in New Mexico, and then Indian tribal lands also have faced some of these challenges, but we're looking at the South. And from this graph, we see that from a high in 1910 of black land ownership of almost 16 million acres in the United States, it has dropped below 4 million acres, or 76%. The same can be said also in Alabama. That in 1910, there was almost 1.5 million acres in owned land, and that's the critical part. That's land that was owned by African Americans, down to less than 500,000 in the 2017 Ag Census. That is a decline of 78%. So then the question is, what is heir property? And heir property is land that is held without secure title, such as a deed. And it has many names. Sometimes it's called family land. Sometimes it's called the estate or family estate. Sometimes it's recorded as deceased or abbreviated deceased. And then sometimes it is labeled as et al., which is Latin for and others. So if you go to the county courthouse or a tax assessor's looking up land, you may find these titles for heir property if it is not labeled as heir property. Now, interestingly, it's also been called heirs property, and you can have apostrophes all over the place. But we're talking basically about the same thing. That is land that is held without secure title. Now, in more legal terms, heir property is a subcategory of what is called tenancy in common ownership. And this occurs when individual tenants in common do not own a particular parcel of land. Instead, you own a fractional interest in the undivided whole. Now, I know that sounds like a lot, but basically it says that all the heirs own land communally based on their relationship to the original owner. You don't own acres, but you own a percent or interest in those acres. So again, it's not secure. And so that you don't own 10 acres or 5 acres or 100 acres, but you own a percentage. You might own 10% or 1% or 50%. And then instead of being called an actual owner, you're called a co-tenant in common. And we'll come back to that in just a little bit. So here's an example. So, and this is just a very simple example. You have a farmer and they own X amount of land, and they have 4 children. And if the farmer dies without a will, which is called dying intestate, then each of the 4 children receive a quarter or 25% of the land. Now, I'm not going to mention the wife. We'll talk about that in just a little bit too. But in case, let's say the farmer, the wife is deceased or they die together, but the next generation then divides it up equally, because these are 4 children from the same person, and then they divide it. So If it were 100 acres, they each would receive 25% interest in that, or it doesn't matter 100 acres or any acres. If there were 5 children, it would be 20%. If there were only 2 children, it would be 50%. So that's what they own in terms of the estate.
Hello, everyone. Like Dr. Zabawa said, I'm Dr. Kara Woods. Thank you for having us, and we'll be tag teaming in and out. So who has heir property? Anyone can have heir property. So this goes from younger and older generations, from producers to PhDs. So it doesn't matter your background, your education level, your experience. Multi-generational owners. So you can have a great uncle and a great niece in the same family. They all own that interest in property. And then first time owners who do not have a will. As we said, that heir property is going to be generated by someone who does not have a probated will. Some causes, or why do we have heir property? The lack of an estate plan is the #1 reason. And like I said, that's because someone has not created a probated will. Another reason is that because of that probated will, they didn't want to create one because they didn't have heirs, or they did not want to have family conflict. So a lot of people don't want to start a will because they believe that it'll start family conflict and have arguments, but it actually clouds or brings a lot of tension to the family after the fact, because then you still have to figure out what we're going to do with that piece of land. Another reason why there's heir property is just the cultural preference or the family desire. A lot of people believe that the talk of death will bring death closer or sooner. But once again, some of these unresolved issues are what's causing heir property. And then as we go into further, it'll cause land loss. In Alabama, so if you die without a will in Alabama, this is how your property or your interest is going to be split up. If you have children with no spouse, then the children will inherit everything. And that's what we showed in the first example, where each child got 0.25%. If you have a spouse and no children, then the spouse will inherit everything. This is when, and after this is when it gets a little bit more confusing. So when you have a spouse and children that belong to you and the spouse, then the spouse will inherit the first $50,000 of your interstate property plus half of the balance, and then the children will will inherit the remaining part of that interstate or without a will heir property. And then when you have a spouse and children who are not the spouse's children, then the spouse will inherit half, and then the children will inherit half. If you have a spouse and parents, then the spouse will receive the first $100,000 of your heir property, plus half of the balance of your heir or interstate property, and then the parents will have the remaining half. Someone who dies and has parents with no children or no spouse, then the parent will inherit everything. And then someone who passes away with siblings, no children, no spouse, no parents, then the siblings will inherit everything. The most important part of this is that if you don't decide what you want to do with your estate, if you don't have a probated will, then the state of Alabama or whatever state will decide it for you. So if you don't give yourself that power, then the state of Alabama will have that power.
And I want to jump in real quick on this as well. If you have no heirs and you die without a will, then the state of Alabama then gets your estate. And then what they will do is they will sell it, and then the money will go to the state. And a lot of people who don't have heirs or think they don't have heirs, they say, well, I don't need a will. Well, there are a lot of ways that you can divide your estate outside of giving to relatives. That is, people will give their estate, for example, to their church, to their college or university, to their high school, to the fraternity. I mean, there are all sorts of ways that you can, you know, put your estate to good use. But if you don't have a will, and as Dr. Woods just said, if you don't decide, then the state will decide. So something to consider.
So the impact of heir property really has a ripple effect, because heir property restricts how the land can be managed, and typically all heirs, so 100% of the heirs, have to agree on any decision that concerns the land. And so that's including division, profits, if you want to add things like a well or a road, anything like that, it has to be decided and agreed upon by all heirs. And so this includes timber harvesting and reforestation, mineral rights, mortgages and loans, which is a lot harder to get when you have heir property, because traditional mortgage lenders will not give mortgages out to a group of 50 people, for example. They really want to know who they're going to get their money from. And so, you know, more than one or two people is not the traditional way. USDA programs and conservation easements are not as easy to get with heir property as well. And to say, if you say, okay, all 50 people out of this family agreed to get the timber harvested, that means all 50 need a profit as well. And so a lot of times that isn't what happens. One person will decide and then one person gets the profit, but that's not how it's traditionally being done. And that's another way that you can have family conflict, because those profits aren't being divided as they should. Heir property also leads to a lot of land loss, and it's a precursor for land loss. So with each passing generation, someone who dies without a will, you're adding more and more people to the bucket. And so typically this means that with each generation, it becomes larger, it increases in number, and so the interest gets smaller. So if you had only 4 children, and then they have 4 children, they have 4 children, as you see, it becomes a lot of people all at once, and then all of them have the same right of ownership, even though their interest might be smaller, they have the same right of ownership, and they can decide what happens to the land. And so as you get further and further from the original deed, some people might not get the importance of the land as much as others, and this can lead to land loss. Okay. Heir property and co-ownership. So with numerous co-owners, there can also be an appeal to management, or how to proper manage the land. Heirs don't have to live on the land or near the land. They don't have to live near each other. They don't have to know each other. Is, you know, many times that you'll be somewhere and someone will actually say, hey, this is so-and-so, this is your cousin, and that's news to you. You've never met this person before, but like I said, even though you don't know them, if they have a blood right to the land, they are as much as an owner as you are, and you might have lived on that land your entire life. Heirs do not have to locate one another, and then they don't have to have a connection to the land. And so that, like I said, goes into that land loss. When you have no connection to the land and how it's of importance to the family, someone can easily say, well, I don't care about that land, I want to sell it. And we'll go into that a little bit further as well.
Also, another thing that was just brought up is blood relations. Now, a lot of times, you know, you have your brothers and your sisters, your cousins, and so on, and these are recognized members of the family. But sometimes, and this happens to all sorts of families, you have what are known as outside children. And just because they are not children born officially into the family, let's say, they also, if they can prove paternity, they also are legal heirs. And that's one of the problems with heir property, is that they have as much legal right or interest in the land as, so let's say, you do. So that's one of the complications as well. Now, in terms of the impact of heir property, is that Since it is unsecured, it is susceptible to loss. And there are two major examples. That is, you can lose property due to tax sales, that is, who pays the taxes, and you can lose it through partition sales, that is, individuals who want to sell their particular interest. Now, going one by one, tax sales occur when you don't pay your taxes. And this is for Macon County. That is, taxes are due in October, and they become delinquent after December 31st. And then over, I think might be a Tuesday or Thursday in April, they have what they call an auction, where you buy the tax deed. Now, what they do is they'll have, it's all in person and it's cash. And the revenue commissioner will bring up a particular piece of land, and they'll say how much taxes are due on that piece of land. Then people bid on it. And then the highest bidder will then receive what is called a tax lien certificate. Now, if they continue to pay those taxes continuously for 3 years, then that land becomes theirs. Okay. Now, up to 3 years, the technical owner, the person on record, has a chance to buy back that tax deed. That is, they have to pay the taxes that the person who got the lien on has paid, plus they pay, in this case, 12% interest. So there are a lot of people who will come to these auctions and they're looking for particular pieces of land. All this land is online. You can go to the revenue commissioner's office, or you can get on your computer and go online, and you can see which pieces of land where people have not paid their taxes. And you come to the tax sale in April and you can bid on these pieces of land. And some people bid on large pieces of land, and then some people just bid on smaller pieces of land. And some of them have houses on them, some are just plain fields. And then some of them don't even hope to keep the land, but they're hoping that the original owner will come and then they get 12% interest on their money. Now, tax sales also occur because you have one person who lives near the land and they continuously pay the taxes, and everyone else just takes it for granted that, Uncle Joe or Cousin John is paying the taxes on it. Now, some people are under the misinformation that if you pay taxes on the land, that you have more rights to the land. That's not true. And ideally, everybody who has interest in the land should be paying their share of the taxes, but that doesn't usually happen. So just because you pay taxes doesn't mean you have more interest in the land. You're just doing a good job, I guess. So if that person who has been paying taxes for years and years and years, if they should pass away and no one remembers, oh wait, Uncle Joe or Cousin John, they were paying taxes. Who's paying the taxes now? That's when land comes up delinquent. So that's one way that people can lose their land to a tax sale, because they assume it's continually being paid. After 3 years, then it can be lost. Now, some people say, well, what if somebody pays my taxes before they become delinquent? Well, that's good for you. If someone pays taxes before they become delinquent, then they're just paying taxes for somebody else. But the key thing is you need to know who is paying your taxes, or who is paying the taxes on the land, and that it continues. Now, partition sales are something completely different. That is, a partition sale occurs because one of the co-tenants common decides that they want to have their piece of land. It is, they don't want to have just a percent, but they want to have their actual acreage. And this means then that the owners or the co-tenants have to get together and decide that this person has a 10% interest in the land, and let's say it's 100 acres, so that might be equal to 10 acres of land. And what happens is that if the person who wants to have their acres doesn't agree with that 10 acres of land, then it goes to the court. The court will then try to decide which 10 acres this person can have, which can be difficult because land is not uniform. It is maybe a part of the land has a pond on it, part of the land has timber on it, part of the land has a house on it. So if they can agree, then what they'll call this a partition in kind, and then they've agreed that will occur, and that person gets the 10 acres or whatever. However, if they cannot agree, then what happens is the courts will then order a partition sale. That is, the whole piece of land will be put up for sale. That is, it will be put up, it's usually on a Saturday at the courthouse steps, and they will auction off the whole piece of land. And then after court costs and so on, each person will then get a portion of that sale money based on their interest in the land. Now,
and you also have to buy that cash.
Yeah, it's also a cash sale.
Yeah.
Now, just because you don't own acres as an heir property co-tenant doesn't mean that you can't sell your interest. Okay, so if you have 10% interest or 1% interest or 100% interest, you can sell that interest to anybody you want. And this is where it gets really kind of tricky because land gets outside the family. That is, a speculator may look and see there's a piece of land, and he can look up who the co-owners are, excuse me, and he may find that there's a co-tenant that lives in Chicago or Detroit or LA. And he'll call that person up and say, I see that you own some interest in some land in Macon County. And they go, really? I didn't know that. Yeah, it's, I guess it's maybe even, not even an acre. And, you don't know anything about it, evidently, but I'm willing to take that land off your hand, that interest off your hand. How about I pay you $1,000, cash money, check I can send it right to your bank in 10 minutes. And that person says, wow, I didn't even know I had any interest in this land. $1,000? Sure. So now this person who's on the outside is now on the inside, and they have as much right to the interest of that land as the family does. And then what they do is they can initiate a partition action. And if they can't do it, partition in kind, then a partition sale. And then when they have that auction, the other family members, you've heard the saying, land rich but cash poor. The people may have had this land in the family for generations, but then all of a sudden they're asked to pull together and which could be in the hundreds of thousands of dollars if it's 100 acres, $1,000 an acre or more. They can't come up with that money, but this person who got in there, that was their intention all along, and they have their check ready to give to the courts, and then the land has been lost. Now, as a quick example of how many heirs we can have, and people say, oh, my family's not that big, 5, 10, 15 people, whatever. I have a quick example. I have a staff member who has some heir property, was asking some questions about it. And I said, well, how many heirs do you think you have? And they thought for a second, said, oh, no, 1,000, 2,000? And I said, how can that be? And they said, it just seems that way. So we did a little bit of looking. And we'll call this the Johnson estate. And Mr. Johnson was our colleague's great-grandfather, and he was born in 1862 and died in 1939. And he purchased 3 parcels of land. In the 1890s, he purchased 63 acres. In the early 1900s, he purchased 80 acres. In the 1920s, he purchased 34 acres. Okay, so here, you have a nice chunk of land put together. So how do you get so many heirs? Well, Mr. Johnson had 8 children, and then he dies intestate, that is without a will. So now this land becomes heir property. Now, if you take the person that I know, the staff person, and go up their direct line, the person that they're related to from Mr. Johnson, the H, had 13 children. So if all 8 children had 13 children, like this person's direct line, that's 104 heirs now. And the person in direct line from that 104 had 9 children. And if all 104 had 9 children, that's 936 heirs. And then she has 2 children. And if all 936 of those people related to her had 2, that's 1,872 heirs. So you can see very quickly that you can go from one person with a nice chunk of land to almost 2,000 people all having an interest in that land.
So we've talked a lot about heir property and how it results from the individual. And so you have like a loss of investment value and then also the loss of potential revenue or profits. Now we're going to go more into how heir property affects the community. At the community level, you have a loss of tax value, and this is because heir property is not evaluated the same profit or the same value as regular title property. And this lack of taxes in these communities, this affects the schools, road infrastructure, access to hospitals, and these are all linked to the property taxes and the population of those living in those areas. Unpaid taxes also causes property depreciation, which means it's going to go lower in value, and then that can cause some communities to be abandoned or have a stigma against them, and so you have people who move out the community, which again means that you have less taxes. So we have an impact of heir property on personal and community wealth. This is going to highlight Macon County. This is where Tuskegee is. And so on our GIS website with our commissioner, our revenue commissioner, you can look up where all the heir property is in Macon County. And that's going to be highlighted in this pink. So as you see all these parcels, these are heir property in Macon County, Alabama. And then you get to the numbers. So you can see how we have over 1,100 heir property parcels with 903 owners. That's over 12,000 acres. And then we go to how this land is valued. So we have over 23 million in land value, 12 million in improvement value, and then overall, when you add those together, that's going to be over 35 million. And so one of the things about heir property is that the improvement value and the land value is going to be substantially lower, just because heir property cannot be improved at the same rate. As we said earlier, those who have mortgages and loans, you're less likely to get them if you're an heir property owner, which means that you don't have that cash influx, that cash to just add to your land and improve it as you would. And so then when you average that out, that means that, out of these parcels, you divide it by that 903, we have 13.6 .63 acres. And then as you see, the land value is almost 2,000. The improvement is almost 1,000. And then the total, like I said, if you add those together, it's almost 3,000.
Yeah, and this is a really, really important point. That is, you can have two pieces of land, that is, let's say 10 acres of air property and 10 acres of property that's secured with secured title. And just on the face of it, they may be, the tax value could be the same. But because one has a secure title, the owners can, let's say, get a mortgage, put a house on it. Now that's called improvement value. So now its total value is greater than the air property, and therefore there's more taxes paid. Now, if you were to even look at it from a different angle, let's say that there was a USDA program that would help prevent erosion. And because it was their property, the co-tenants are not eligible for that program, whereas those that have title to their land do. So that they have erosion control, and that piece of property maintains its value, whereas the other piece of property, which originally was the same, assessed value as the title property, because it was not able to take advantage of a program, therefore has erosion, and now its land value is less than that of the title value. So again, air property, you just don't have as many options to improve on it, to be able to capitalize on your investment, and then also the community in terms of being able to get more taxes.
And as we've said, air property is found in a concentration of more African American where they live. So these Black Belt counties or these Black communities, they'll have a chance of more air property, which still means that you're not getting the same amount of money into these Black Belt or Black concentrated areas. And so, like we said, that means that, the schools, the roads, the ways to get to hospitals, they're not getting those same resources. So in Macon County, how we have the percent of value from air property to title property. The total acres, and this is going to be done with just the total acres, agricultural acres, and then residential acres, is only 54% of the value of a title property. So it's essentially half of the title property is air property. So that you're not getting that same rate of money. Like I said, that resource is about half. Land value is at 58%. Improved value is just at 40%. And then the taxes that you get from these pieces of property is at 57%. So you can see, like I said, the difference in rate of how you can improve your community as a whole with these property values and these property taxes.
And basically, from the community level, that 57% is really important. That is, for every dollar that a piece of title property might pay in taxes, you're only getting 57 cents for the air property. And I think we had a study with Macon County, and the difference mounted in the hundreds of thousands of dollars. And I don't know too many counties who would mind having that extra money for their teachers, fire department, police department, roads, bridges, schools, and so on. So there's been some work. I mean, air property has been a concern for many years now. And there's been some legislative work dealing with that. And one of these pieces of legislation is called the Uniform Partition of Heirs Property Act, or the UPHPA. And it was proposed in the year 2010. And basically what the Uniform Partition Act does is it gives the co-tenants in common some additional rights to the land to protect it from being sold either through, mostly through partition sales. So for example, if someone is doing a partition action against a particular piece of land, all the other co-tenants have to be notified. That is, it can't be just a couple people that sort of behind someone's back tries to sell the piece of land. That is, all co-tenants have to be notified. And the example of the 1,800 possible co-tenants, that can take a bit of time. Second of all, the Act says that you have to have an independent appraisal of the fair market value. That is, it cannot be undervalued or overvalued to keep people from buying, keeping the co-tenants from buying the piece of land. So this independent appraisal. Thirdly, the other co-tenants have right of first refusal. That is, if you have an assessed, the fair market value, all the other heirs have an option to say, we're going to buy it first and keep the land in the family. Okay, they get that first option. And then if they decide no, either they can't or don't want that option, then it has to be a reasonable sale supervised by the court to ensure that a fair share is given to all the tenants. Now, it's not a perfect law, but what it basically does, it gets all the other heirs or co-tenants some time. That is, they can't just get a notice in the mail that says this Friday or this Saturday there's going to be an auction on your property. It is, they have to be notified, has to be a fair appraisal, they have the first right of refusal, and then the courts will also supervise the ultimate sale if it gets that far. So time is the big measure for this act. Now, this act only applies, again, to heir property, and it only applies if there's no other agreement in terms of the, who gets what pieces of land to the other co-tenants. Since 2010, we've had several states that have adopted this act, and when it says uniform partition, what they're saying is that they're trying to make it across states. And interestingly, Alabama was in the first group in 2014 to adopt this law. So in Alabama, we do have the Uniform Partition of Heirs Property Act. 2020 was a big year in that New York, Virginia, Florida, and Mississippi have all joined as members and have now enacted this act. And then we have 7 or 6 states and then DC who are now having this act introduced by their legislatures. And here we can see the states in the dark gray are the ones that have enacted the Uniform Partition of Heirs Property Act. And then the states in DC that are in the blue are those that are being introduced this year. And then another legislative arena is the Farm Bill. It was the Farm Bill of 2018 called the Agriculture Improvement Act. We just call it the Farm Bill. And there are some provisions in the Farm Bill for heir property owners. And the parts of the Farm Bill that deal with heir property were introduced by, or co-introduced, or co-sponsored by Alabama Senator Doug Jones. Without going into too much detail here, and the Title V of the Farm Bill is for credit, and Section 5104 talks about a relending program to resolve ownership and succession on farmland. And basically what this section talks about is that there is money set aside that the Secretary of Agriculture can give to organizations that work in this area. It could be cooperatives, credit unions, legal assistance, or whatever, to assist people or assist co-tenants, heirs, to resolve their heir property issues. So there is a program in the Farm Bill that will help people to resolve their heir property issues. The only problem, however, is that there are no regulations or methods on how to give people access to that program. So the program is there, it is funded, but I think it goes through Farm Service Agency, FSA, but they still have to come up with the regulations for the procedures on how to access this money. So that's a potential assist. And then under Title 12, which is called miscellaneous, there's section 12615, a mouthful, called the eligibility for operators on heirs property to obtain a farm number. For those of you in agriculture know that to access USDA programs, you have to have a farm number. And if you had heir property, it was very difficult, if not impossible, to get a farm number. But what this section of the Farm Bill says is that if you can get at least 51 co-tenants who together own 51% of the overall percentage of the land, they can be then designated as the owner in terms of receiving that farm number. And therefore, you have access to some USDA programs that you did not have access to before. So basically, it's kind of a majority rule provision in the Farm Bill. So it could be one person has 51%, and therefore they can then apply for the farm number, or it could be 10 people, or however, as long as it's over the 50% mark. So between the Uniform Partition of Heirs Property Act and the Farm Bill, there are some provisions to help heir property owners.
Yeah, and so what's important about that is that it does help farming and agricultural land, but we're still working on how to improve it for all heir property owners. So this doesn't include that heir property that is not farmland. So how to avoid heir property? The first thing is to have an estate plan or to write a will, and that way you have the power in designating what your will say, who will get your land, your property, your assets, and you have that power, and you're not giving that power to anyone else or to the state. The second thing that you can do is to create a LLC or a trust, and that gives the power to the family. And so then you actually have like a board of executors that are going to have equal rights in deciding what you should do with the land, who's going to pay the taxes for the year, and it gives a lot of people accountability as to how they're going to take care of the land each year and also keep it in the family. With both of these things, though, you would need a lawyer. So once again, we're not a lawyer, but it's going to take a lawyer to do these things.
Especially if you have a lot of co-tenants.
And lastly, remember, if you do not decide how you want to divide your estate, your land, your property, then the state will. And so in other words, if you don't have that estate plan, if you don't create that power in that probated will, the state will decide it for you. So some exercises that we have thought about just so you can get the actual idea of heir property and how you are or may be connected to heir property. So the issue with heir property is dependent on two factors. One, your relationship with the original owner, the person that is on the deed. And so, for example, you could be a son or a daughter, a niece or a nephew of the person who's on the original deed. And then two, how many generations have passed since that original owner? So in the Johnson example, 3 or 4 generations have passed. It was her great grandfather. And so how many generations have passed from the original owner, and that kind of tells you how big of a family tree you have to start thinking about how many people are involved. In general, the longer the time or the longer the generations or how many generations from the original owner, it means that that has a more increase of heirs or potential heirs, and so therefore the share interest from the original property gets smaller with the increase of people. So example, 40 acres in 1865. So this is right after the emancipation of slavery, and the 40 acres and a mule has also often been a basis of where newly emancipated people have built on post-slavery and how they created their future. And so over the 155-year period since the Civil War to date, till 2020, 7.75 20-year generations have passed. So that means with each 20 years, like someone has been able to extend the family line. And that means that 8 generations, if we round it up, 8 generations have passed since that 1865 emancipation. And so if each member of that generation had 4 children, by 2020, that means you would have 65,536 potential heirs. And so if you just had that original 40 acres and you divide that by that 65,000, that means that each person would have a shared interest of 0.0006 acres, or about 26 square feet. And this means that it measures to approximately about 5 feet and 1 1/3 inches square. So as you can see, that 40 acres, it becomes small really fast. And even though you could have potentially 65,536 heirs, each of them has the same right to ownership. And that means that they can decide what happens with the land or what doesn't happen. That means that they are still responsible for paying those taxes. And so you can easily see how tax sales or partition sales can happen, and you can lose that land loss. And this, although it doesn't seem that far ago, this is how it happens with heir property when you have that many people that can be potentially involved.
So we wanted to do an exercise for people that are watching this. And so to do that, what you need to do is count your number of brothers and sisters, okay? And then either on your mother or father's side, depending on where the land might be coming from, count the number of his or her brothers and sisters. That would be your uncles and aunts. And then the number of their children, your cousins. Now add the number of you plus your brothers and sisters plus your cousins, and that gives you the number of potential living heirs. Now divide the number of potential heirs into an imaginary 40 acres. And there's another example we took out here. What would your potential share in acres be? So if you had, between you and your brothers and sisters and cousins, if there were 10 of you and that 40 acres, that means that you each would have 4 acres. If you had 40, that means you each have 1 acre, and so on. So what would your potential share be in that 40 acres? Now think about that. Is it better to use this land as an individual or collectively in the family? That is, do you want to keep that 40 acres in the family? And if you do, how do you do that? Or would you want your individual piece of land? Would you want that individual 10 acres or 1 acre or 5 square feet? And to think about it, do you have this similar situation in your family? It is there heir property? How many heirs are there? And what can you do to, how can you decide how to use it? And even more importantly, or just as importantly, do you have property and do you have a will? That is, if you have, you might have 10 acres somewhere. If you don't have a will, then that becomes heir property when you die. And then you don't have control over it anymore. So do you want to have, do you want it to go to a particular child or children or so on? So again, as we've said several times now, if you don't decide, the state will decide. So now you can then write down some questions and you can send them to us and we can try to answer them. But as we said before, you will need a lawyer. And one other thing that we do want to mention, and I'll take it back to the Johnson estate. And if you remember, Mr. Johnson was born in 1862. And this is in Macon County. And as we were discussing this with our colleague, he was born into slavery. But they were also able to trace when Mr. Johnson's mother was born. And she was born in, I think it was in 1820s. And it was before Alabama was a state. And then they had the first name of Mr. Johnson's mother. And it's theoretically possible that she was born in the 1790s. George Washington was still alive. And this could have been their Eve for their family. This person could have been the person that came from Africa. So from that person up to Mr. Johnson, there was no land ownership. He then became a landowner. And that land then becomes very, very, very important to them. And so now they're asking these very important questions about how do we keep the land in the family so that it doesn't get sold out from under them or used for purposes that they don't want to happen. So these are all questions you need to ask in your family, whether the land has been owned for generations and what it means to the family and to you, or whether you're the first time landowner and you're the first person and you want it to go on to other members of your family. So these are all questions you need to ask, and hopefully this presentation has been useful and that you can start those interesting family conversations and hopefully find a way to secure your land. Thank you very much.
So if you have that resource, you have to, realize and put that power in it and make sure that you're going to be the one that delegates how it will be divided. And so again, Dr. Carol Woods, thank you for having us, and Dr. Robert Zabawa. And if you have any questions, we look forward to getting them and also helping you figure some things out.
Thank you.